Nnamdi Kanu case declared academic. Nigerians explode. Is this justice or injustice? Welcome to EloPace TV. Thank you for always watching my videos. If you have not subscribed, please do so and turn on your notification bell so you can be notified anytime we drop new updates. Today's story is one that cuts deep into the heart of Nigeria's justice system, human rights debate, and the long-running saga involving the leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu. It is a story that touches law, politics, fairness, and the relationship between the Nigerian government and the southeastern region. This is not just an update, it is a window into a much bigger conversation about justice in Nigeria. Ngwanu, let's begin. The Abuja Division of the Court of Appeal on Friday struck out an appeal filed by Nnamdi Kanu, challenging what he described as violations of his fundamental rights by the federal government, the DSS, and the Attorney General of the Federation. This appeal was originally filed while he was still in DSS custody, with complaints that he was denied access to his lawyers. He was not allowed to change clothes despite court orders. He was denied access to his personal doctor. He was not allowed to practice his religion. That means he was not allowed to go to church. He was held in solitary confinement. His health was getting worse under DSS supervision. DSS medical staff allegedly took his blood samples multiple times without providing a medical report. His legal team argued that these actions amounted to human rights abuse. However, the High Court dismissed his suit. Kanu then took the matter to the Court of Appeal, Kojeme Appeal. But yesterday, the Court of Appeal also struck him out. Why? What was the court reasoning? Let me tell you the reason. Asena, according to the lead judgment delivered by Justice Bolu Kurumo Ugo, the appeal has become an academic exercise. What does it mean? It implies that the situation has changed. The relief being sought is no longer applicable. The court cannot rule over something that no longer exists because Kanu is no longer in DSS custody. His lawyer, Barrister Maxwell Opara, confirmed to the court that Kanu is now a convicted person, serving a life sentence, detained at the Sokoto Correctional Centre. As a result, the court said it cannot hear a case that is tied to its former location, DSS custody. The court also had said, since he had previously said he preferred prison to DSS custody, that preference has already been met. Then case was struck out, matter closed. But that is not the full picture, because that is not all that he reported on. This is where the conversation becomes intense, emotional, and extremely important, not just for Kanu, but for every Nigerian. Because this issue is bigger than one man. It is a question of whether our justice system truly protects the rights of detainees, whether powerful security agencies can be held accountable, and whether technical legal arguments should override moral obligations. Now let's break it down. Legally, the Court of Appeal followed the rule. In law, a matter becomes academic when the court cannot enforce the relief requested. The underlying situation has changed. The decision will have no practical effect. The issue is no longer live. So, from a strictly legal point of view, the court was not wrong to say Kanu is no longer in DSS custody. We cannot order a transfer from DSS to Kuje prison. Therefore, the case no longer has practical meaning. This makes sense in courtroom logic, but there is a but. But fairness requires a deeper look, and this is where people feel uneasy. Kanu's complaint did not disappear simply because he is now in a prison. And those alleged violations, denial of legal access, health issue, solitary confinement, clothing, no-go church, all this will happen during his time with the DSS. And I know that he has been complaining about it. Now you are saying that he's now in a prison, so it is now obsolete. I prefer the word obsolete because this academic exercise you are using is not entering my brain very well. Law or no law, the question is, should a court ignore possible human rights violations simply because the detainee has been moved? This is where the ruling becomes questionable. Very, very questionable. It gives the impression that past violations do not matter. It also gives the impression that if someone is abused in custody, the abuse does not expire once they are transferred. Yet the ruling treats the issue as if it has evaporated. It also gives the impression that DSS conduct can be avoided. It avoids examining the DSS conduct. This is critical. The DSS is a powerful agency, quite all right. The only real check on its power is the court. And now, if courts refuse to review allegations once detainees are moved, then the DSS can simply do as they like. They can delay, they can ignore complaints, they can transfer detainees strategically, they can even allow the courts to decide cases irrelevant. This is a dangerous loophole. And this also creates the impression that the system protects institutions more than individuals. What is the role of the court? It includes protecting rights, investigating claims, restraining government excesses. Even if someone is convicted, they still have rights. The ruling, however, sidesteps the rights issues entirely. The human rights angle, does conviction erase rights? Absolutely not. A prisoner has the right to health. A prisoner has the right to legal representation. A prisoner has the right to dignity. A prisoner has the right to religious prayer. Should not be subjected to medical mistreatment. A prisoner should not be denied basic clothing. A prisoner should not be held in unlawful solitary confinement. A guilty person does not become subhuman. A convicted person is still a citizen. Now, if the court had examined Kanu's claim, it could have clarified detainee rights, held the DSS accountable if wrongdoing occurred, set guidelines for future cases, strengthened justice for all Nigerians. Instead, the court avoided the issue entirely. They avoided the issue pata. We must also acknowledge that this case is occurring within years of tension in the Southeast, historical grievances, political complexity surrounding IPOB, mistrust between the region and the federal government, and national insecurity. Fairness in such a case is not just legal, it is political. The court refusal to even address the substance of its complaint sends a symbolic message to many in the Southeast who already feel marginalized. And that is why we have to do things and do it right. Even if legally justified, the ruling raises the question, is the justice system sensitive enough to regional tensions and historical distrust? Even if the court could not order a transfer, it could still declare whether rights were violated now. It could still review security agencies if necessary. It could still reaffirm the constitutional rights of detainees. It could still establish standards for future conduct. This ruling offered a chance to strengthen the national belief that justice applies to everyone, even unpopular figures. But that opportunity, una miss am, una show us the opposite. Now let me analyze the national implication, what this means for Nigeria. This decision affects the rule of law. Citizens need to believe courts will review state misconduct. It also affects human rights. If detainees can be mistreated without accountability, the entire justice system is weakened. It also affects security agencies. Unrestrained power leads to abuse. It affects public trust in the judiciary. Already low, this ruling does not help. It affects the Southeast federal government relationship. The dismissal without examination may deepen mistrust. Finally, was the Court of Appeal legally correct? Yes or not correct? Was the ruling fair, balanced, and morally sound? Mba. Many Nigerians, including legal experts, believe the answer is no, or capital no, because justice is not only about technical correctness, it is about fairness. It is about accountability. It is about protecting rights, even when the person is controversial. Protect her. Protect it. Even when the person is convicted, he is still a citizen. Even when the case is politically sensitive, a court should not avoid addressing a human rights claim simply because it is inconvenient. That is the heart of the issue. The ruling may have followed the letter of the law, yeah, but did it uphold the spirit of justice? This is a big question that everyone in the judiciary should answer. This is the big questions, and the debate will continue. The debate will continue.